on appeal matter 2025. Kindly consider lordship put on in the top list today item number 534 combined monthly list. Kindly put on in the top list lordship.
Pardon?
Put on in the top list. Top of the list.
Why?
Top of the list lordship.
Why?
Lordship petitioner is suffering.
Wait for this week.
May I be
Lordship,
permitted to mention one PL matter, old matter relating to the illegal plastic factories operating in the residential
Please
premises.
don't mention for upgradation
For
any new
inclusion
matter, please mention.
For inclusion matter, that old matter, it is not in the list.
Old matter of which year?
2021 matter is a change brief of mine. 2021 is a change brief of mine. That's why I'm mentioning it.
So what is the status?
But it has never been heard.
Never been heard.
Yes,
Then
madam.
what remains for after two years?
There is subsequent changes. There was a green bench order passed in this in favor of the petitioner, where it was restrained and they have moved out from the place. But
So you
later on,
make out a supplementary evidence.
I will, my lord. But for that reason, my lord, I need your lordship's direction to prepare a supplementary and to direct to the direction to further service to the state, my lord. Because
Where
this
is
only-
your notice to the other side?
my lord, may it come in the. I have to give them, my lord. After
Sir, you don't see. We insist.
I have seen, my lord.
Give
Lordship.
notice and mention.
Wait.
Kindly allow me to mention, Your Lordship, one matter, Your Lordship. This item is 153 of the
Are you
combined.
mentioning upon notice?
Yes, Your Lordship. Yes. Lordship, the
The combined list matters.
combined monthly list, Your Lordship.
Yes, combined monthly list one. You remind us with after a week. You
Ye-
remind us after a week.
Great.
Yes.
I have your
kindly work on my lord, because the penalty I am mentioning one matter before the Honorable Acting Chief Justice. My lord, sitting with Honorable Justice Partha Chatterjee was supposed to hear one matter for several days, and his part had matter. Only one day is required, my lord, to complete.
Yes, we
the land tribunal
we shall arrange. I shall talk with Mr. Justice Chatterjee. We will arrange. We will sit one day so that we can take up some matters. You will get the intimation.
So the change of the government, I again soft copy.
Oh, I see. Now, did
Again,
we
soft
fix any date? Did we fix any date?
Initially, it was fixed on 27th April, but
Thereafter, nothing.
on that day not appeared.
Very
Thereafter,
good. We,
kindly, my lord. The item number 533 of my lord's monthly list, my lord.
please don't mention for
My
upgradation.
lord,
sir.
kindly bears with me for a second, my lord. The only urgency is that this is a pill matter, my lord. We have the matter is of pertaining of the deterioration of the roads, bridges, as well as the pathways in Howrah. My lord, the last order has been passed on 29th of October by this honorable court, and after that, my lord has this honorable court has
Sir,
directed.
what is the urgency?
The
Tell us.
urgency is that, my lord, due to this monsoon season, my lord, there are a lot of potholes.
Wait for some time. We cannot upgrade all matters now.
Mention a matter.
Waiting seems
Well, this matter pertains to defalcation of fund in Shaha.
want application or
No,
here?
my lord, this matter I want to include. The matter was appearing twice. My lord, Union of India seek for time. My lord was directed the matter to appear 2 weeks hence, but thereafter it disappeared from the list. I'm great.
My lord, may I be permitted to mention one?
Application the other.
My lord.
Notice, give a notice and come.
Very good.
My lord, may I be?
On your lordship permission, I am mentioning my matter for upgradation. Matter was already fixed, my lord, on 7th July at 2 p.m. But despite that, matter has not been come. It is a dismissal from service matter. He is
7th July it was fixed.
yes, my lord. It is the last order. It was fixed on 7th July.
So why didn't you remind us next day that it is a fixed matter which has not appeared? Now where is it?
It is in the month list, item number
Naturally.
138, my lord.
130. Wait for some
My lord,
time.
may I-
Let's see how do we proceed. Upgradation we cannot allow. And the upgraded matters, you come and take action.
My lord, may I?
Yesterday also all this happened.
May I
Yes,
be permitted to mention one tribunal motion, my lord, for inclusion in the
tribunal
list.
motion.
Tribunal motion, my
It
lord.
was not heard.
It was, my lord, it was taken up for one day, but that on that day respondent took time. Now, my lord, difficulty is the urgency is respondent has filed
contempt application before the Central Administrative Tribunal against the Union of India. My lord, this matter was never heard, my lord. I have already indicated the respondent that I will mention today.
ওটা নিয়ে নাও একটু।
Is ready, my lord. The matter was extremely hard and made
You
part hard
remind
matter by
us
the.
after 2 weeks, let us see how we proceed.
Doctor, may I be permitted to mention for inclusion? It is a new mandamus appeal, Your Lordship.
Are you mentioning upon notice?
Lordship, I have the affidavit of service. It's a
You
new,
know that it was never heard.
never heard. It's a new appeal.
So it must have appeared on the returnable date. When
No,
was
Lordship,
the
it has not come in the list. It has not appeared in the list even once. Lordship,
Method of which year?
of 2026. It's a new appeal, Lordship.
What is the returnable date you gave in your filing?
Lordship, have to check.
On the returnable date,
Lord-
all matters appear. Either adjournment taken, that is why given adjournment, otherwise all matters appear on the
Lordship, the
returnable.
returnable date was 12th of August.
12th of August. Today we are,
Today's 13th. Today's 13th, Your Lordship. So it did not appear.
you know, দেখো,
Grateful, Your Lordship.
yes.
Your Lordship, I'm mentioning this matter for inclusion, Your Lordship. This is a new matter. We have not served a notice, Your Lordship.
Give a notice and come back.
Lordship, may I have your Lordship's kind leave to mention one hearing matter for inclusion, your Lordship? It's a
When
2020
is your
matter.
notice?
I have served, your Lordship.
When?
I have served on.
That you will mention today.
I had, your Lordship, it was given on a prior date. I had given also.
Pardon? Pardon?
I had given a date and thereafter, as
Give a notice and come back. Mention on Monday with a notice.
Very
Yes, call the list.
I'm for the petitioner, my lord. On last occasion, my lord, please to start the respondent number 15. Once again, I have served, my lord.
Lord, I'm appearing for respondent number 15. 13 এখানে।
কালকে ছিল না এই মামলাটা? শুনানি শুরু
Identical আরেকটা মামলা।
কবে ফিক্স করেছে?
14 সেপ্টেম্বর।
14 তারিখে যেটা ইয়ে হবে।
হুম।
My lord, identical matter being taken up by my lords on yesterday. Similar matter, same place. Only difficulty in this application is this, my lord. They have made Midnapur irrigation executive engineer East Midnapur division as a party, but the answering authority will be Kontai. My lord,
there are other
we have-
defects in the cost title as well, my lord. Private respondent has been added by name, and beside his name there is a mention of secretary, but secretary of which club, which society, it is not mentioned in the cost title.
You know now of which club.
My
you
lord,
are
I have been served by name, my lord.
No, you
Last-
know now which club secretary you are.
I am,
My lord,
but my lord, that's the
Another
my lord,
thing is there,
one
my lord.
more thing, my lord. We have not received any notice for this joint inspection. I have taken instruction yesterday, my lord. It is on
Yes, my lord.
14th
On
of August.
14th of August already. Yesterday, my lord, the similar matter was taken up, which I have
Yes,
placed the
yes.
instruction. 14th of August, inspection date is being fixed. Now, so far as this present matter is concerned, they have made East Midnapur irrigation department a party. The
Is
answer,
it also pertaining to the same area?
same area, but here, my lord, cost title needs to be amended. It will be contact.
What you are giving? Yesterday matter appeared, we passed an order.
My lord.
Last occasion, my lord was pleased to ask me the name where it is written as secretary. Osim Rahman is secretary. There is a invitation letter where it is written as secretary.
So then you are conducting the inspection when?
14th of August, my lord.
14th of August.
Yes.
And we have made that matter returnable when?
14th of September.
14th of September, man.
But no notice for any of the inspection has been given upon us.
You take notice, be present on 14th.
Kindly give us
My lord,
liberty, my
all
lord,
the
to
concerned authority, BDO, BL and LRO, irrigation department, every will be there on 14th.
including the parties.
Executive
You
engineer
have
will
got
also.
the intimation.
I am
now
led by
you
Mr.
go and attend the inspection. What is the problem?
I'm sorry.
Sit down, sit down.
No, no. Better. Item number 1.
We have been informed that a similar matter has been fixed for further consideration on
Lord, the public interest litigation, my lord, is directed against my lord, with the leave of my lord Justice, my lord, acting Chief Justice, my lord, may I welcome my lord Justice Banerjee to the bench from my seat. My lord, is directed, my lord, against the English Bazar municipality, not on 3 counts. My lord, first of all, in the name of mutation fees, my lord, the fees which is being charged is, my lord, not prescribed by the count. Second, the completion certificate for all the buildings are not being issued, thereby, my lord, keeping the sword hanging on all the constructions. And number 3, my lord, for the common spaces, a commercial charge even for residential buildings is being charged from the developers or whoever is constructing the buildings. Now, my lord, these are the 3 counts. Now, my lord,
why public interest litigation?
my lord, I am not personally interested, my lord, in any building. I am not a developer, but my lord,
So
I am a
if
resident.
if the additional amount is taken from the developer, where is the
I'll
developer?
tell you, Lord. It passes on to the consumers. There are no developer in the world, perhaps, pays it out of their own pocket. If it is being charged from the developers, this passes on to the consumers who are the residents.
Then should be the allottees who are to be challenged.
No, my lord. 1 allottee, 2 allottee, my lord, may come, but this issue is pertaining to the entire municipality. Number 1. Number 2, my lord, one of the developers approached the writ court, my lord, in a 226, two writ petitions. My lord, in 2 writ petitions, directions were given not to seek this excess amount. I'll take your lordship through the orders.
Mr. Banerjee, first tell us what is your public interest when
I'll tell
writ
you,
matters are pending. Writ matters pertaining to
disposed of with a direction upon them in one matter to consider. I'll place those orders, but I'll only explain the public interest, my lord. But the excess whichever is collected will ultimately pass on to these citizens. Number 1. Number 2, but if there is no completion certificate.
Come to 36. Protection has been given. Writ petition pending.
Yes, my lord, there is the final. My lord,
then after this, what prompts you to come?
My lord, 36 is disposed of.
Yes, the remedial measure has been directed.
My lord, for one developer.
That is pertaining to this
But
municipality.
this is pertaining to this municipality for Gaurbongo Developers Association, who is the pro forma respondent here. Since, my lord, I have relied on the orders passed in their writ petition, I have made them the pro forma respondent here, my lord.
No, you
So
are
I have no
also-
prayers against them.
You are also aggrieved by the English Bazar municipality. No?
Yes, that it is entire municipality is happening. My lord, in the orders passed, the orders are in personam. My lord, only pertaining to the developer who approached the court. I'll tell you, lordship, my lord. Kindly comes to the 2 orders. First order kindly takes, my lord, at page 27. First one. It is with regard to charging of the mutation fees. Deholds the directions of the Urban Development and Municipal Affairs Department. My lord, kindly come to the directions. Page 30. Third paragraph. May I place it, madam?
Yes. Yes.
In view of the above, the municipality is directed to accept nutrition fees strictly in accordance with the said aforesaid rule. The municipality is also directed to refund the security deposit as has been collected, my lord, kindly see, from the applicants applying for mutation before the municipality at the earliest but positively within a period of 90 days from the date of submission of the receipt or so and so. Therefore, this particular order, which is pertaining to mutation fees, is pertaining to the applicants only, number 1. Then kindly comes to the next order. That is starting at page 32. Well, the operative portion of which, which fell from your lordship.
Municipality has been directed that you are bound to take direction as per the Municipal Affairs Department.
And the rules, Rule 121. Now, my lord, what is happening? It is only with regard to that developer that these orders are operating in the entire municipality.
Is your allegation? Show us an instance. Show us an instance that further charges have been made after this order.
I have annexed a
There
memo.
is nothing, Mr. Bandowar.
Well, can you take page 26? I have given a, but I cannot have challans, my lord, and invoices for all. But can you take page 26? But there, the better copy should be at 26A. And Malad, there's ample of pleadings, Malad.
What is the
From
date?
paragraph 3 onwards, Malad.
What is this date?
Malad, I beg your lordship's pardon, Malad.
What date of
Malad, this is pertaining to the first quarter of 26 to the fourth quarter of 27.
Yes.
Meaning this current year. And Malad kindly takes my pleadings from paragraph 3 onwards. Malad, 3 to 9 is pertaining to all mutation fees. 10 and 11 is regarding completion certificate. Well, I have made positive assertions in my PIL. It is not, Malad, out of the blue that, Malad, I have come, Malad, with any personal interest or having any personal vengeance against the municipality. But,
Yes.
Malad, I wish to point out, Malad, if there is an illegality, two counts. One is the statutory violation and the other is the violation. Even if your lordship reads the two orders at page 27 and page 36 as orders in rem, then also it's a violation by the municipality. Now, Malad, I only want to, Malad,
that is why court has intervened.
Malad, in pertaining to one developer, what I'm beseeching your lordship, Malad, your lordship sitting in the PIL jurisdiction, Malad, if your lordship sees the illegality, wherever it is found, your lordship, Malad, ought to, Malad, interfere. As far as locus is concerned, Malad, I'll beg to submit this, Malad. When on the face of it there is an illegality, Malad, your lordship sitting in 226 jurisdiction, Malad, will try to, Malad, undo that injustice, Malad, wherever it is found. Number one. Number two, Malad, if the cause is ultimately helping the public, your lordship will be, Malad, loath to look into my locus. Malad, if I may only rely, Malad, I was aware that the municipality may flag the issue of my locus, Malad, because I had made a representation and they had replied to the same, Malad, saying that you have no locus in this. Malad, kindly, Malad, sees there, when I flagged this issue with the municipality, their only reply is that you are nowhere connected to these two petitions. Therefore, I will not reply to you. Could get my hands on, Malad. This is of 13 July 2026, but not in a PIL. But I'll place two judgments in a PIL, Malad. Malad, this is with regard to, Malad, which I was trying to, Malad, beseech your Malad. Malad, kindly takes, Malad. But this is Union of India versus Baliram. Malad, this is
for what proposition here, please?
Malad, your lordships, Malad, when Malad is exercising 226 jurisdiction, Malad, your lordships will reach out to the injustice wherever it is found.
That you have already said.
Yes, Malad. For in support of that, Malad.
Why should we look into an order passed in between two parties?
But I'll
in
place,
this
Malad,
public interest.
regarding
Your
PIL
argument
also,
is sitting in writ court. You
PIL
can
also I'm placing, Malad. But if your lordship, Malad,
what proposition you are giving?
49, 50 and 50 are given. 49, 50 and 53.
Necessarily initiate.
No, I'm sorry, Malad. But I'm sorry. Just give the. Malad, not 53, Malad. I'm sorry. Thank you.
We have asked you a simple question. You want the municipality should not charge in this fashion.
My lord. From any of it.
Right. From any of the applicants. Now, in an inter-party litigation, there has been a direction of the court that municipality is bound to act in terms of. Now, in that event, even after that order, if a further step is taken, that is for the allottees who suffered to go and say
Well, I'll tell you this. Well, what
Mr.
I'm,
Bandyopadhyay, kindly appreciate. If there is a, we could have understood that they are moving in a situation that nobody is there to prevent them from doing this. It was a litigation between the promoters or the royalties. The municipality was involved. Court has intervened, passed an order. Suppose you are if you are a social activist, then you should advise your members to file independent writ petitions in spite of this direction if the municipality does
well,
not.
I'll tell you. Well, why I brought this litigation before your lordships, my lord. Each and every person, each
Show
and
us
every.
your what Supreme Court ordered you are relying.
Well, I'll just indicate the paragraphs, my lord. I have missed the note, my lord, with regard to that, my lord. My lord, kindly, my lord, takes.
Para?
Kindly, my lord. Just. My lord, kindly, my lord, skips over this judgment, my lord, giving the paragraph, my lord. One.
This is a service matter.
Yes, my lord.
Petition.
My lord, while placing it, my lord, I said, my lord, that this is, my lord, not pertaining to a PIL. 1914.
Then what proposition you are citing?
My lord, injustice must be reached wherever it is found. My lord, I indicating the paragraph. My lord. Kindly gives me a second, my lord. Kindly takes this for the timing. 49, 50, and 53 of this judgment.
Just now you are relying upon this one.
This one. Well, the paragraphs, my lord, I have just.
Yes. 49.
49, 50, and 51. 3.
This is also a writ petition.
But discusses PIL.
That you have said your injustice wherever seen must be gone into.
Yes, my lord, even my lord, and
It's
in
from
that
1970 onward.
In that process, PIL is a tool in your lordship's hands. That is mentioned in paragraph 53. Kindly take 49. May I place it, Malak? Again, this court in Air India Statutory Corporation so and so held that the founding fathers placed no limitation.
Paragraph
49. Well, I'll come again, Malak.
Yes.
Again, this court in Air India Statutory Corporation held that the founding fathers placed no limitation or fetters under Article 226 of the Constitution except self-imposed limitations. This court held that the arms of the court is long enough to reach injustice wherever it is found. The above authorities of this court clearly lays down that power given to the High Court under Article 226 is power of very wide nature, which does not contain any fetter except self-imposed restrictions. It is well settled that the High Court, while exercising jurisdiction under Article 226, shall not issue any direction which is contrary to law. Then 53. 53. When the government agencies failed in unearthing offences of magnitude, the doors of the constitutional courts have been knocked by the citizens to come to their rescue. One of the tools of this court to advance justice and fulfill the constitutional objective is recognizing a special category of litigation, namely PIL. So, Malad, kindly, Malad, marries paragraph 49, 50, and 53 together, Malad. Malad, in reaching that injustice, Malad, one is the allottees approaching the writ court separately. And the other tool in your lordship's hand is the PIL. And my lord, with regard to locus, my lord, there has been a. My lord, there is a division bench of our court. My lord, coincidentally, my lord, your lordship was in the bench, my lord.
So you were of the opinion court will not entertain, let me take all judgments.
No. In their reply, municipality in their reply took the only point of locus. So, my lord, I came prepared with the point of locus. They did not say that I am not committing the illegality. I'll take your lordship to the reply. They say that you have no business in asking me this question.
Sir Bandyopadhyay, ask your allottees to move similar petitions.
I have no allottees, my lord. I am, my lord.
Whoever is your well-wisher, you are a political activist or any.
I am not. I am not even a political activist.
So you tell your persons who are seeking advice from you to go.
But it is not so. It is not so, my lord. Illegality
Mr.
is in
Bondar,
front of me, my lord.
Our contention, kindly listen. You have raised and you are contending municipalities acting in derogation to the provisions. This issue was urged in an inter-party litigation. Court has given a direction. In such cases, if this direction is violated, naturally the allottee's private right would be interfered with. There cannot be, what should you like adding further support to you, as if there will be one litigation here for all the allottees in West Bengal and individual litigations will follow. Public interest litigation is not to be said for utilization in this manner. We could have understood that there was rampant illegality, nothing was done no protection was given by anybody. Protection has been given, Mr. Bondar.
But even this is not implemented. Even this order is not implemented. But I am not agitating that cause. I am not agitating that cause. It is for them to approach the writ court. Statute and infringement of the orders, assuming the orders are in rem. Only that much. Only that much is my contention. Because my job is to bring the illegality to your lordship's notice. As a medium being the PIL. Your lordship will kindly not allow the municipality to proceed with this illegality. Let them implement it. Let them implement that order at least.
Yes, who are you appearing?
When I am for the private respondent number 6.
Who are you?
But I am the Developers Association who moved a application before the Honorable Writ Court, Millard, and the orders at page 33 were passed at my writ petition, Millard.
Very good. Yes, Mr.
My lord, I am representing the municipality.
Municipality, yes.
Now, my lord, the very first point that I am urging the very first point that I am urging your lordship, what has been fallen from your lordship that the main.
This is the first point. Oh, you have other points also. Oh.
But first he has to pass the hurdle of maintainability. My lord, before your lordship, the affected party, nobody is coming forward. There is no such, my lord, if there is any at all any grievance, substantive grievance, they should approach by way of appeal or other.
So unless you are approached, you do nothing.
My lord, that is not the issue. But I am, my lord.
So what is your instruction? Municipality has now taken any decision?
My lord, with regard to the, my lord, these two orders, as these two orders are already there. Now, what is these two orders in 2022? Now, my lord, the outcome of these two orders, whether it has been, my lord, given effect to, or because the parties, the petition are there.
Been given effect to.
My lord, to that effect, my lord, I need to take instruction. I have asked for.
I made a specific point, not effect, not given effect.
To that effect, my lord, I need to file a comprehensive opposition because there are several allegations. And penalty point should be kept open. Because the affected parties who are the, my lord, directly affected, there is no such grievance ventilated in the court itself, even after 2022. That was the order. Now, my lord, outcome of the order that I have asked for to give me instruction what is the outcome. Now, if this order has not been implemented, then my lord, this Gourbongo developers, who is the party, they certainly they will come to the court and say so. Now, my lord,
what you are being charged after this order.
To that effect, I don't have any instruction. Just to assist your lordship, if the order ought to have been implemented, then page 26 would not have been annexed with the writ petition.
If they have implemented the order passed by her ladyship in the single bench, then Miller page 26 would not have been issued.
Why?
Well, it is the order was passed in the writ petition which was filed in the 2022.
Yes.
And Miller, this page, this is for a demand for the financial year 2025-26. That is the current present financial year.
Yes.
This is Miller after passing of the order passed in the writ petition filed by us. That is Miller, the respondent number 6.
So is this in compliance of your?
No. I'm not saying that. I am saying if the order actually have been implemented, then Miller, the municipality would not have come up with these types of demands.
A negative
But
argument? I'm asking you. We are asking you this memo. You are satisfied with this?
No, I have nothing to do with this. This is not issued in my favor. This is not charged upon me. This is something
with
they
regard
thought.
to property tax, Malote, that
To others. It is with
property
regard to
tax, and
others.
it has to be looked
Yes, you are appearing for whom? State.
My lord, I have very limited submission regarding the point of maintainability. My lord,
That memo is being violated.
My lord, I read the writ petition, my lord, very minutely. What I found, my lord, a person preferred a representation. My lord, praying to implement two writ court's order. My lord, that person is, my lord, was not, my lord,
that
he did not participate in the earlier writ petition. My lord, how this is possible? I put a question to Misil.
That is a reply.
My lord, kindly see that is.
Yes.
Gaur, my lord, both the writ petitions, Gaur Bongo Developers Association and others, these two private litigations are there. Two orders are there. My lord, the representation was preferred by the writ petitioner praying to implement those earlier orders. And now they file a public interest litigation. How this is possible? I am trying to find out, my lord. My lord, I am searching this question, my lord. My lord, how this is maintained?
Their memo at page 24 is being violated. Their memo. Well, I am trying to protect the patent substance of their memo, and they are opposing my PIL on the ground of locus.
All right. The present public interest litigation, bracket in short P, has been preferred.
Since my lord, I have handed it over, I can get paragraphs.
Upon the is the direction upon the
If any assistance is required, I just was instructed.
to refund the amount received from bona fide flat owners and developers in exercise of what is chargeable under Rule 120. এখানে আছে to refund such and such, page 18.
To refund me, Lord, the amount that has been recovered. May I be given a liberty, me, Lord, to take appropriate steps?
On what basis?
Lord, I am the
Public interest litigation preferred by him, and you are praying.
Don't say something when you are not the writ petition. Yes, next.
I am for the petitioner, Lordship. The service is not affected upon all the respondent. If your Lordship kindly give us 1 week time, Lordship.
The learned advocate appearing for the petition.
Number 4, my lord. The state.
I am for the appellant, my lord. My lord, may I short pass over, my lord.
Okay.
My lord, I am for the appellant, my lord. I am praying for short pass over, my lord. My lord, only 5 minutes or 10 minutes, my lord.
No pass. 2nd September. 2nd September.
My lord, in the meantime, the subsequent development has been there, my lord. I filed an supplementary affidavit, my lord.
Wait for. Yes.
My lord, this matter.
Petition has not been moved. You are wanting supplementary affidavit.
Very well, my lord.
Petition has also not been.
Have you served the copy?
Mr. You are appearing for whom?
That I appear for the state.
State. Oh.
The affidavit of service, my lord, and
This is with regard to, my lord, filling up of the post of a principal in a college.
Filling up of
post of principal.
What?
An alumni of the college has filed the writ petition. Now, my lord knows under the 2017 rules, my lord, when there is a vacancy, my lord, we can, my lord, depute the vice principal to officiate as a principal.
Course of hearing, the learned advocate appearing for affidavit of service, as filed, be kept on record. In course of hearing, the learned advocate appearing for the petition.
Lord, I am appearing for the petition in this matter.
Yes.
Your Lordship, I represent the state respondents, Lord.
Yes.
One thing, Lord, so far as the facts are concerned, my Lord, I need to come back with instructions, my Lord. And so far as maintainability is concerned, my Lord, if my learned friend permits me, my Lord, I can just indicate, my Lord.
Then you take in, when we start hearing Mr. Bandyopadhyay, then to
Submit in a
talk with Mr.
No, my Lord,
Bandyopadhyay.
this is extremely urgent. I have taken leave. What is this similar? What they have done without giving any notice? Which is now become the practice of the present government. There is no written notice, nothing. Calling in the police stations and to stop loudspeaker, removed loudspeaker from all mosques, 4,000 mosques in the state of West Bengal. This has become a practice now that the no written order would be served. Police will implement the written order and 4,000 loudspeakers have been removed in the Ajan. mosque, and this law is settled by this court. This court and also Supreme Court. Your Lordship knows that Justice Bhagavati Banerjee's judgment is also there that you can use the loudspeaker, but strictly in compliance with the sound decibel. That was confirmed in the High Court division bench. That was also confirmed in the Supreme Court. Even the Milord, the notification which has been used has been issued by the state government. This notification also in conformity with that, and these loudspeaker are being utilized in the mosque for calling the Azan at the time of Azan. And this was also confirmed by the division bench presided over by Justice Bhagavati Prasad Banerjee. Even then, now kindly see
what they have done.
They have removed, the police has gone and removed all loudspeakers.
Where is your pleading to the defendant?
My lord, kindly see.
There is none.
So then you start, let him start.
No, Mr.
No, this Advocate General, whenever he will come, he has to speak first.
I did not.
No, there is none. Page 5, paragraph 5. As per the information received by the petitioners from various imams, secretaries and presidents of religious places in the district of Hooghly, a series of meetings were convened by the Angas, Krabdani and Telinipara town outpost of Bhadreshwar police station, as well as the Rishta and Shirampur police station district. These meetings were attended by the representatives of various mosques and temples within their respective jurisdictions. During this meeting, they said, representatives were unequivocally directed by the police officials present to remove with immediate effect the loudspeakers that had been installed on the towers and premises of their respective place of worship. At the time of issuing this direction, the police authorities failed to produce any written order, circular, or notification from the government or any other competent authority authorizing such a sweeping action. Then Lordships kindly come to paragraph 7. Paragraph 7, page 6. Furthermore, as per the information and understanding received by the petitioner, this practice has not been confined to one locality. Rather, similar meetings and instructions have been reported as having taken place across with the various districts and towns throughout the state of West Bengal, indicating a pattern of action orchestrated by respondent police officials. In several instances, these directions for removal also have not been communicated in person, but have been conveyed over telephone conversation, further denying the recipients of so and so. The following the said meetings, police officers have been visiting the mosque on a frequent. Well, police is going out at the top of the mosque. What is happening in the state of West Bengal? And regular basis, wearing shoes, and have been persistently insisting the loudspeaker currently installed in the mosque towers be removed forthwith. This ongoing and repeated applications of pursuit of the police has not been confined to isolated or one-time request, but has instead amounted to continual and systematic insistence, accompanied by an expectation of immediate compliance.
Here, you're agreed by their oral direction to remove the loudspeaker.
Yes, and the loudspeakers have been removed.
So where from do you find 4,000 mosques?
Yes, I am coming. Yes, this is not my. This is also statement of the Chief Minister. He speaks in the assembly, never issues any order.
So the
Your Lordship has seen that cases, that Anganwadi cases, the ISKCON case, issued. That time Advocate General has come and said, no, nothing is there. Then it has been implemented. We have mentioned this matter also. This has become practice of that. Kindly come, paragraph 18.
Paragraph
18, page 12.
What interim order you want?
But I am asking for interim order to allow us to use the loudspeaker.
Did you make such prayer to the authorities?
How 4,000 mosques? How can I do it?
Exactly. So 4,000 mosques details are not here, Mr. Bandyopadhyay.
Pardon me, my lord?
Presentation is.
It's a PIL, my lord. Your Lordship, if you go on technicalities, I have no case.
No, naturally, some
No,
technicalities.
Not that technicalities.
No, we are asking questions.
No.
We are asking
No.
4,000 mosques. Which are those mosques? In which district?
In all districts of the West Bengal.
Mr. Bandyopadhyay, you should specify that this you have annexed.
At least I have stated in Hooghly district almost. You have seen that?
Page 129. That representation which you have.
Yes. That's the only representations.
Yes.
There are 3 representations. 129, 134.
So let us hear Mr.
Can I just give me 3 or 4? Tell me.
Yes,
let me tell your Lordship.
Yes.
My lord, your Lordship is aware, my lord, when that the air pollution was sound pollution was a really subject matter, and in fact, it was stated that the Justice Bhagavati Banerjee was taken the first. He is the first judge in the India. So far, the sound pollution is concerned, he has delivered the judgment. My lord, kindly come to first judgment. I will just show to your Lordship. That's the, my lord. Kindly come to this judgment page at page 38. It starts. Page 38. It starts. The judgment.
You are praying for an interim order to direct the authorities not to direct anything verbally and not to take coercive steps in places of worship to remove their loudspeakers. This is your prayer.
Use of the microphone, for the purpose of use of microphone. Prayer G, kindly see.
Yes.
Prayer G is also there. My lord, what I am trying to just satisfy your lordships on the point of laws, etc. Kindly come to page 38. This is judgment. 19 SCC online, Calcutta 130. This is Birangana Religious Society. Your lordships have heard that the crackers matter first came. Crackers. Then, my lord, your lordships will kindly come to page 44.
Yes.
Paragraph 27. Accordingly, it must be held that powers of the police, district magistrate or subdivisional officers to grant permission to use microphones is subject to certain restrictions and conditions which are necessary in order to protect and preserve a very fundamental right of the citizen under Article 19(1)(a). Then directions have been given. Kindly come to Milord D. The person or persons or any business house dealing with or letting or selling the microphone speakers, kindly see. And the operating apparatus shall be bound to see of the Pollution Control Board before letting or parting with or selling with such appropriate for any purpose. In default, therefore, thereof, they should not be permitted to deal with such items for this purpose. The Pollution Control Board shall issue directions from time to time in this behalf. Loudspeakers should not be allowed to operate in the streets between 9 p.m. in this evening and 7 p.m. in the following morning for any purpose at any time for any purpose includes so and so. Now, my lord, I, so far as use of the microphones and loudspeakers by way of religious organization or at any religious place for the use of religious communication, it should also be used solely for the purpose of communicating the speeches and or religious teaching and or tends to the person who have been attended such function and so open as so and so. Paragraph 28. The volume and noise should be approved by the West Bengal Pollution Control Board, and the same should be enforced by the police or and the administration. So far as the public meetings, I am not interested. Now, my lord, kindly come to this paragraph 30, page 46. Page 46, paragraph 30, guidelines are directed to be issued. Then, my lord, the judgment. Kindly come to page, my lord. This is a 47, page 40. This is another judgment. Maulana Mufti Sayyid Muhammad Noor Rahman Barkati and others versus State of West Bengal. The division bench judgment. कौन कंट्रा আছে কোড paragraph page 66 straightway. Very relevant portion I will show to you, lords. Page 66.
Page 66.
6, yes. It's a part of the judgment of the division bench. Paragraph 17. I am coming to a very, just a relevant portion. Right to sleep is not only a fundamental right. It is to be considered as a basic human right. The effect of a bad sleep and no sleep was considered by this court in Barabajar fireworks case, which was approved by the Supreme Court. Accordingly, it cannot be contended that by use of microphones before 7 a.m., which has the effect of distribution and taking away the right to sleep, cannot be agitated on the ground that the same is an essential and integral part of it. No religious text or book has been brought to the notice of this court that use of microphone or user of any other machine, excepting the human voice, Ajan could be given, not Ajans through a microphone. This court has not prohibited, kindly see, prohibited the giving of Ajan, but only had put a restriction on the use of microphone. Ajan is given 5 times in a day. There is no difficulty for 4 times, but in the early hours before 7 o'clock, Ajan could not be given throughout the microphone. Therefore, Ajan was allowed to use microphone, but not before 7 a.m. That was a judgment. Now, my lord, kindly see the paragraph 69, that all this, my lord, this big judgment I would not want to place now. Now, kindly come to paragraph 29, page 71. It is made clear that from the date of this order, if anybody is found violating the restriction imposed on microphone loudspeaker, the police authorities are hereby directed to immediately seize and confiscate and the microphone from whatever place it would be found and reported it to the court for taking drastic action against the violators who are violating willfully. And the officer in charge of all police stations in the state of West Bengal are directed to keep a watch on all the mosques in the state of West Bengal to find out whether any of the mosques are using microphone in the early hours before 7 a.m. But that they are maintaining the decibel limits available to them on the basis of the situation of the mosque, and if any infraction is made, they should take steps as directed in this order. Further, all this police will answer. Now, there is no complaint anywhere has been made according to this paragraph. Now, my lord, kindly come to the Supreme Court judgment. My lord, the judgment of the Supreme Court on noise pollution. This is kindly see come page 78. This is this has been taken all India with a pan India basis. This is a reference noise pollution in RE. Supreme Court has taken it pan India basis. Then there, my lord, will find that the judgment was Calcutta High Court judgment was upheld at paragraph 151. Kindly see. The Calcutta High Court in the case 151 paragraph. Now this is pan India. 151. The paragraph 151.
Yes.
The Calcutta High Court in the case of Maulana Mufti so has expressed the following view. Extensively it has been, you see, Lordship has been relied upon. Now paragraph 152. The picture of the, can I read below 152? The picture of the entire country compared with the state of West Bengal does not bear any material difference. Thus, a rule, practice, or provision as to relaxation of Europe and America may not be much help for that. They do not have any festivals, so and so, so and so. Now, Millard, kindly come to paragraph. Millard, this is kindly come to paragraph 175, 127. 127 is the page. 127 is the page. Paragraph 175, man. I'm sorry. Paragraph 175. See, the notice level at the boundary of the pub. Kindly see two loudspeakers. The noise level at the boundary of the public place, where loudspeakers or public address system or any other notice source is being used, shall not exceed 10 decibel A above the ambient noise standard for the area or 75 decibel A, whichever is lower. No one shall then beat a drum or tom-tom or blow or trumpet or beat at sound of any stage, so and so, so and so. The peripheral notice of level of privately, so and so, it has been given so far the noise level is concerned. Now, I am just going straight away to the 2023 notification of the state government. Kindly come to page 35. Kindly excuse me, Millard, I will give the, that's not a very clear, page 35. Now see, Millard, this is the notification. This is 17th October 2023. Now, similar circular of standard operation procedure for organizing domestic or communication festival celebration pujas in the state of West Bengal for ensuring the environmental norms in compliance with order dated 7th August 2023. There is Justice, my Lord Chief Justice Sivagnanam judgment. I will just show to you, Lords. Now, Muller, it is annexed. The object of the standard, so and so kindly see. Now, microphone to be used and operated after obtaining permission from the concerned police authorities or distinct authority and to abide by all the terms and conditions fixed up by the police authorities. So, microphone to be used or operation fraction, sound limit with the amplifier system for maintaining ambient noise standards as specified for different areas as per the relevant action, so and so. Then they will have the category noise levels. Daytime, nighttime. Now they have allowed now daytime and nighttime. What Justice Banerjee has said, from there state government has deviated. Now see, limit in decibel area, liquid, daytime, industrial, I am on concern about residential area, 55 and nighttime 45. Notification has issued, my lord, in terms of the division bench judgment, that is that page, my lord, kindly see. I did not judgment. Then I am show you the rules. My lord, kindly come to page 73. This notification was issued. And relevant portion is, my lord, kindly come to page 73. This is, my lord, pursuant to that directions of the division bench, this notification which I read that has been issued. Then we will kindly come to page 73 and relevant portion is at page 77. Bearing all the above in mind, it is appropriate for the state of West Bengal to formulate a standard operating procedure so that the same can be known to the general public and to strictly implement the same much prior to festival season and other celebration either celebrated publicly or privately confined to a group of individuals or families. Therefore, this is so far is this order is concerned. Now circular has been issued. Now your lordships kindly see two things just I point out. So far, Azan is concerned, judgment of the division bench is applying 4 times, not before 7 a.m. you can't utilize, correct? And entire gamut of that judgment was from 10 p.m. to 7 a.m. No loudspeaker. Now here by this notification, daytime, nighttime has also been allowed. Nighttime was prohibited by division bench. It is against me, but I have to tell the law. But by this notification, they have allowed it. Decibel has been decreased. Now I show to your lordship the rule which is prevailing now. Kindly come to Miller paragraph, page 28. This is central government rules. That is the rules, noise pollution regulation and control rules 2000. This is applicable pan India. Now kindly come to paragraph, page 30. Page 30. The state government shall take measures for abatement of noise, including noise emanating from vehicular movements, for blowing of horns, so system, and sound producing, and ensure that the existing noise level do not exceed the ambient air quality standards specified only under the rules. Now, Mulad, kindly come to the schedule. Schedule of this. Page 34. This is, my lord, this schedule, rules. Here also daytime and nighttime is permitted. So what state government has issued this circular, that is in consonance with the rules. After 99 judgment, rule has been brought by the central government. Therefore, decibel or the time factor, that has been taken care by the legislatures. Therefore, this is the rule is applying. If this is the rule is applying, then Azan, at the time of Azan, loudspeaker can be utilized before 7 a.m. also.
But for that Azan, loudspeaker is not required. 7 a.m. which the Azan which you are giving, for that you are using loudspeaker, which is regulated by the terms of the Azan. Now, what is your grievance now? Now Azan giving has not been stopped.
Loudspeakers have been removed.
Yes, loudspeakers have been, that is your allegation. I'm just wanting to know prior to 6 a.m. in the morning, where you are not required to use the loudspeakers as per the procedure. Now, after that bar, your ajan at the time of performance of ajan, you need to use loudspeaker.
Yes, after 7 a.m. I have to use, no?
That explanation what you have given in that why you are required to do that you must have stated in your petition.
But that has been decided by this court in the division bench judgment. Division bench judgment, let me tell you lordship very shortly, that it is not fundamental religious right to use microphone for the ajan.
Yes.
Correct? That has been held. After considering that, the division bench has said, yes, when everyone can use the loudspeaker, during the time of ajan also you can use the loudspeaker, subject to decibel, subject to 7 a.m. to 10 p.m. The point which, if I am right, that your lordships want
can use the loudspeaker subject to the sound restriction.
Sound restriction.
This is your content.
This is my contention. Whatever is their rules, etc. Why the religious discrimination? Let me make it very short. See, Millard, if we read the entire thing, including division bench judgment, that if anyone in violation of the order and the decibel limit, if anyone uses, police is having authority to confiscate and to put it before the court. Correct? Number two, loudspeakers at the time of ajan is also allowed, subject to that restrictions. Here what is happening? There is a circular of 2023 also. There is not a written order in a single place, I have said so.
Yes.
Calling the persons in police station, over telephone, imams are being said, stop it. Now police is going there and removing the loudspeakers. Now, if I have violated, then one case. If I have violated, then appropriate criminal case should be started. Confiscation and send it to the appropriate court. Court will decide it. Here, no confiscation, no cases has been made. Police is judging the entire case. And police is not allowing to use the loudspeakers. And entire thing is oral.
Yes.
Only on oral. We have said in the representations also. And also we have said, give us an order. My lord, I can challenge anything. The order must be there. If a government decision is there, order must be there in the public domain. So that if any public is having any grievance or individual is having any grievance, can come before the court. It's a random practice now, no issue, public notice.
Joining an issue that is only restricted to Hooghly, but you are making the petition pertaining to the entire West Bengal.
Yes.
Entire allegation.
Allegations, I have said so.
So that they have to reply, Mr. Bandyopadhyay.
But they let them say that they have not removed.
That is your, no, that he will ask.
That your lordship, what I am, what
We understand your argument, but we are saying, Mr. Bandyopadhyay, you are saying on the basis of one representation issued in respect of a
three references I have given in three different places.
4,000 mocks, don't.
That has not been in. No, that has. Kindly appreciate the ground reality. Ground reality is something different. I can understand, Milord, your lordship is asking the question. Milord, time and again we are saying that day Mr. Bhattacharya has also said in one matter. Kindly appreciate the ground reality. No, Tuina, I mean Vikas Bhattacharya. Mr. Vikas Bhattacharya, one case was saying, no, why তুই একা ভট্টাচার্য নেই অনেক First representation is at page 129.
Mr. Bandyopadhyay, kindly one question I.
Yes, my lord.
Suppose today the interim order which you are wanting, you want us to issue direction upon the state that you should refrain yourself from going to any mosque and from removing the loudspeaker.
Yes.
Pass that order.
Correct.
In your favor. When it comes to us in contempt, how will we implement that order? There must be a specific instance, specific mosque, specific.
Very nice. Your lordship restricted to the Hooghly district is concerned.
Hooghly district.
I have given
presentation on 7th of August.
So,
here on 12th of August, an allegation made to the district magistrate by a statement signed by some person. What is the?
These some persons are not just street persons. Some persons are very responsible imams.
So at least you will also say this, that this needs to be verified. Now we need to know the stand of the state.
I am not saying, my lord, that your lordship will not. I am not. Am I saying that? I am not saying. Now, up to 7th August.
That you give a reply to the contention of Mr. Bandyopadhyay as the regulatory process. There is no HON'BLE order on the basis how you are proceeding. Then they will say that allow me to give an affidavit, I will come. Interim order, Mr. Bandyopadhyay, please tell us that you, in respect of Hooghly district, you do it. Tomorrow a contempt application will come. Now, whom we will hold up?
Whether this court will not pass any interim order on an anticipation that so many contempt petitions will come.
No. We are asking, we are not anticipating. We are asking
No,
you to implement your order.
We must your lordships will implement. There is a way to implement. If there is a breach, suppose let's Hooghly district is concerned. If they don't remove, I will not come up with a contempt in a vague thing. I will come up with a contempt on a specific thing. I am also a responsible person. They are imams. They are not just the street pants. Who have given this? Kindly read this letter. Page 130. Kindly come. Who has signed that? Kindly see. Muhammad Javid Ansari, President, Masjid Aklu Misti, Champdani Hooghly. Jamil Akhtar, Secretary, Masjid so-and-so. President, Angus.
That the contents of the representation, not the signatories of the representation.
No, your lordship said that the signatures were. What I am trying to impress upon your lordship is these signatories are in respect of the one after another mosque.
All right. Yes, Mr.
This is not the, this is not the 3 or 4 mosques I am saying about. I am saying that by this representation, in an area where the mosques are there are hundreds of mosques are there within the Chapdani municipality.
All right.
With responsibility, I am saying. With responsibility, I am saying, if it is required, I will give the details with the responsibility. I am saying, within the Rishta municipality, with a 5 wards, 50 mosques are there. in a Sirampur municipality, in an area where the 30 mosques are there.
Yes.
I am not talking, Lord, on air. And kindly see, then the next representation is 134. This is Jama Masjid, page 134. This is Imam Muhammad Zakir Hussain. On the day of Eid, at least 50,000 Muslims present there. They are not an irresponsible person, my lord. They are all are very responsible persons.
Yes.
Then the representation made by the lawyer. Well, these are, therefore, I am praying that this is the situation. And in terms of the High Court's order, at least for the division bench judgment, your lordship, this is my case, would be, our submission would be, irrespective of fact, 4,000, 5,000, 8,000, 10,000, or 100. In a PIL, High Court has passed an earlier order. It is a continuous process. We are also before the division bench. Your lordship should see that the directions contained in the division bench order. I am not taking the advantage of this judgment orders. Then I will get more. This can be strictly complied with. Because that is on a single matter, entire West Bengal has been controlled.
Yes.
Then the pan-India judgment has come.
Yes.
These are my arguments.
Yes.
Well, Lord, if your lordships are not contemplating of passing any interim order, I shall take direction and come back. Otherwise, my lord, I shall submit before your lordships that, my lord, this petition is liable to be dismissed in limine with exemplary cost. Should not be touched even with a birch pole. Kindly look into the petition. Who is the petitioner? I'll tell your lordship. Who is the petitioner? A lawyer, not a lay person. First paragraph. First paragraph, my lord, he is a lawyer. So he knows, my lord, it's not, my lord, he cannot say that, well, I have given it to my lawyer, he has drafted, I have merely signed it. So no, he is not. Kindly come to the next paragraph. Paragraph 4, page 4.
Yes.
The present petition raises issues of substantial public importance concerning the legality of verbal directions issued by the respondent authorities. Kindly pause here for a moment, my lord. Who gave this verbal instruction?
That is exactly what we are asking from you. What is your stand to this allegation?
It was served yesterday in any event. Well, Lord, can the court, my lord, proceed on the basis? Not a single name. Kindly proceed. Of various places of worship for removal of loudspeaker irrespective of their compliance with applicable statutory law, etc. Members of different communities were called. Paragraph 5. As per information received by the petitioner. From whom?
August representation.
No, I shall come to that. Does he say, well, if police comes and police calls for a meeting, well, that is the representation police had called for a meeting. Now, well, who was the officer concerned? I will not say. Mr. X has said this. Now, my lord, your lordships were pleased to ask a question to which, my lord, responded. I ought not to have responded. About, my lord, where have they said about removal of the loudspeakers by police? It's my inability to find it out from the petition. There is no whisper, my lord, subject to correction that police has removed anything.
that paragraph 5 in the middle of it, they have
Yes.
stated during these meetings, the representatives were unequivocally directed by the police officials.
Police did not do anything. Don't stop there, my lord. Kindly read that along with, my lord, paragraph 8. So on third, my lord, some anonymous police officer gave direction that remove it. Then kindly come to paragraph 5. Following the said meetings, police officials have been visiting the mosque on a frequent and regular basis. Who? If I may ask myself the question, no particulars. And they want, pilot, a lawyer wants the court to proceed on the basis of this petition. Then kindly proceed. And have been persistently insisting that the loudspeakers currently installed on the mosque towers be removed. So after third, it was not removed. Which mosque? My lord, we have heard, my lord, the allegation is, or my lord, the allegation in the petition is 4,000 mosque. Not a single particulars.
Are you meaning to say that police has not even gone there, told anything?
I have to take instruction, my lord.
Tell us that he's. You are right about the amendments we are considering. His main allegation is twofold. First is subject to what you say. One allegation he made is that these directions which are given for removal is not backed by any order whatsoever.
My lord, your lordships are proceeding on the basis that direction has been given.
No. We are proceeding on the basis as to what is the substantiality about this fact. You are saying that no police has gone there to remove the loudspeakers. That is what you are saying. No particulars have been.
The petition does not say. The petition does not say, my lord, that the police officer has removed any loudspeaker from.
Very good. Then they have been asked to remove the.
Very well.
Yes.
Yes.
Now,
who, my lord, if I may, my lord, as far as I know, my lord, the little I have known, that, my lord, if somebody comes up before the court, my lord, he has to first establish his case. Has he, my lord, if I may ask myself the question, has he established the case that, my lord, a police officer, Mr. A, had gone and said that, yes, you do this? Have they said that in their representation that these were the police officers who have done this? Now, my lord, were not this required? Were not this required that you will say this? Not a single imam has come forward. Who is saying? The petitioner is saying, my lord, true to knowledge, that so and so has the names are not given. I have come to know. Here's evidence. Now, my lord, some responsibility has to be taken. As I started by saying, not a lay person, a lawyer is, my lord, the petitioner. He cannot afford to, my lord, affirm such a petition with greatest of respect. So, my lord, everything, my lord, goes, my lord, the rules, my lord, laid down for verification of pleadings, my lord, those goes, everything goes.
That is on the issue of, we understand your argument, but we want to on the basis of the submissions, as this has, what should I say, there has been a plethora of decisions, High Court passed orders, SOP was created, sound decibel system was earmarked by the state. Now they are alleging that police is threatening. This allegation, how do you respond to that? Is it your contention that we have not given any such of direction? This is absolutely false. Then we can proceed on that basis.
Kindly keep it on Monday, my lord. I shall take instructions.
Yes, that you can do. You tell us.
Tuesday, my lord.
Because
Tuesday.
Mr. Bandyopadhyay wants, his primary contention is truth we are not doing. Allegation is that you have rang up from the police station and you have removed
No.
loudspeaker.
I have called a meeting. I have called a meeting. The allegation is meetings have been called at different, my lord, outposts. Again, my lord, no particulars. Now, my lord, today in 2026, or my lord, when somebody rings up somebody else, my lord, immediately we come to know, my lord, who is calling. I do not know, my lord, how many of us, my lord, till use, my lord, the landlines. No particulars. Calls are received, no particulars. Now, these allegations, I could have dealt with this.
Putting aside this petition, please apprise us that any sort of activity to that effect has been done by the state or not.
Kindly keep it for
Because
Tuesday.
if that is your argument, we will adequately deal with.
Kindly keep it for Tuesday, my lord. I shall take instruction. Oh, damn, she job in every. Excepting Monday, my lord, any other day.
Mr. Bandyopadhyay,
Lord, can I just,
yes.
if he has finished,
Let
then
him come with that instruction, Mr. Bandyopadhyay.
just if he has finished, just I will point out to
Yes.
what is he saying. Your statement is coming from an advocate general submissions. Kindly come to page 129. My lord, we are not in a
129.
we are not in a trial on suit. It's a constitutional court.
No, there is no averment. You see, this is the fact that there is no averment in the writ petition that police has gone to the mosque and removed the loudspeaker.
Kindly read 5 and 8.
Yes, come to 5. Come to 5.
First
There is
read,
no
kindly come to
allegation.
first page 129.
Come to that. Come to paragraph 5.
5, yes.
There is no allegation that police has entered the mosque and removed the loudspeaker.
Kindly read this 5 and 8 together,
Yes.
please.
As per the
Lord,
information.
everyone's knowledge of readings is not same, but if the meaning is carried on, that's enough for the PIL.
One advocate is not.
No. Every advocate's knowledge is not same. Is it correct?
Right. That police has.
No. I
entered.
kindly read it. Kindly read it. Kindly read it.
Already read it for us, but still again.
Can I read it?
Yes, you read.
If your lordships like, then I will read. Otherwise, I will not read.
I am hearing you for the last
Very.
45
Then let's kindly read it. As per the information received, so and so a series of meetings were convened by the Angas, Chabdani and Telenipara town outposts of Bhadreshwar police station as well by the Risha and Shirampur police station. We have given details or not? Given these details or not? So I have to give the constable numbers.
You have to say that police has entered and.
My lord, kindly read this. Kindly, excuse me, my lord, kindly read this.
Yes.
These meetings were attended by representatives. During this meeting, the said representative unequivocally directed by the police officer present to remove.
So police has.
Kindly, my lord, give me time, my lord. Otherwise, I am very dull-headed man. I am not so intelligent. Did that had been installed on the towers and premises of the respective place of worship. Now read 8. Read 8. Police officials have been visiting the mosque on frequent and regular basis and have been persistently insisting loudspeakers currently installed on the mosque towers be removed forthwith.
Right. We are saying that whether.
My lord, police has not by hand has been removed. Police is saying you remove it.
Yes.
Paragraph 8 is there. Paragraph 5 is there. Then the ongoing and repeated applications of pressure by the police authorities has not been confined to isolated or one-time, but has instead amounted continual and systematic instances, accompanied by an expectation of immediate compliance. What more I can write? And such sustained pressures and act of coercion have resulted in considerable inconvenience and distress for the management committee who are responsible for the administration and functioning of the respective place of worship. And now, my lord, kindly come.
Let him come with the.
And who is he? He is also by faith. What do
affidavit service. Court is clothed with so much of patience, and for that is to be appreciated. My lord, this is a matter, my lord, arising out of Section 44 of the Transfer of Property Act. Law is that. Law is there. Law is framed for being abode by all and sundry. Here is a case, my lord. Ours is an undivided Hindu joint family, and we know a co-sharer, he has left this place. A co-sharer Yes, Bhattacharya. That is the order dated 30th March 26. Only the relevant portion of that very order below is, yes, yeah, my lord. Ours is a dwelling house, undivided, and there are only two co-sharers. My brother's son, we are belonging to the same family. He is my lord Kallis is my lord. The other co-sharer, police inaction matter. Yes, my lord, I am coming to that, my lord. I am coming to that. It kindly say. No, criminal prosecution has to be initiated by the state, and the case also supports in my face. Kindly see the section 44 I am reading. Complaint with the police is complaint, kindly find it.
Page 96.
Okay. Yes, my lord. Yes. Successive complaints were lodged, and yes, but that does not tally.
My lord,
I am reading
144 order, my lord. Passed by. My lord, that is there, my lord. So far as the order of the writ application goes, civil dispute between the family members, my lord. Nothing, my lord.
nothing. Complaint. I am coming to that, my lord. I am P4, that is the that was registered on the 26th of August 25, my lord, in the name of Rohim Sheikh, my lord. There, my lord, offense were committed, my lord. Kindly find at my paragraph number 23, my lord. I am
And
reading
for the
it, my
private
lord.
respondent number 8, Lordship.
Paragraph 23.
Lordship, there is civil dispute. If Lordship, if civil disputes are no Lordship, relating to land Lordship, relating to land Lordship. I am one of the owners Lordship of that property Lordship. I have transferred my share to another Lordship. If he is aggrieved by that said transfer, he should file a preemption case. This is a law Lordship. And regarding co-sharer, and regarding section 44 Lordship, section 44 what he has want to submit. Second portion, I have not transferred any part of dwelling house Lordship. So section 44 does not apply in the writ court Lordship. And Honorable Single Judge already Lordship in order dictated Lordship that liberty was given because of the right to preemption if it is exists Lordship.
Oh, kindly, one by one, kindly cease, my lord. Page, my lord. The deed number, my lord. P4, 61 to 8. Page number 61 to 82. Here lies the criminal act, my lord. This deed was registered by Siddhartha Mondal, my nephew, in favor of Rohim Sheikh. This is our dwelling house. Rohim Sheikh. Here the valuation is declared to be 88,64,000, while other deeds were registered to the extent of 65,000 only. It is intended to disable me to file any preemption case under Section 8 of the West Bengal Land Reforms Act or otherwise. I cannot go to the partition as because Section 4 of the Partition Act only enjoins upon the purchaser, that is a stranger purchaser to the family, to file an application for preemption or for partition. I cannot go on voluntarily to file any application for partition. I cannot file the preemption case as because too inflated valuation is declared there. How the officials concerned? It is a false affirmation before any court. My Why so? That very deed is invalid. That very deed is invalid. No, my lord, that is the wrong. That has to be appreciated. Kindly see the proviso. That is the second part of the section 34. No one is, I am reading it. Whole transfer by one co-owner, where one of two or more co-owners of immovable property legally competent in that behalf transfers his share of such property or any interest therein, the transferee acquires as to such a share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of the transfer the share or interest so transferred. This part of the Transfer of Property Act gives one right to have an access within the periphery of my house or within the periphery of my property as and when he has purchased. But kindly see the next lines. This is the proviso. Kindly see where the transferee of a share of a dwelling house. It is our dwelling house. Belongs to an undivided family. Ours is an undivided family. He is not a member of the family. He is a stranger to the property. He is a Muslim by caste. Acha, nothing in this section shall be deemed to entitle him to a joint possession. So he cannot have an access within the periphery of this property, within the periphery of this dwelling house. And it is the duty of the state to prevent all other persons who are having any bid to have an access within the periphery of my house.
No.
So police is duty bound to protect me.
He has annexed the deed.
Law is there. Law is there.
Portion of Bastu, not the dwelling house. Everybody's dwelling is separate, Lordship. Lordship, kindly see page 31. Page 31, Lordship. Page 31 in the middle portion, Lordship. Lordship. In the second last line, Lordship, in schedule, 787 Borgafut, Bastu, O Pukur Pade Jumi, Odrakar Vicar, clearly mentioned, Lordship. Sold, Lordship, third person, Lordship. Third party is one Probir Naya. Naya, Lordship. Probir Naya at page 27. His description is there, Lordship. It is on 22nd August 2025. Yes. Lordship. No. Only it is vacant land, Lordship. Lordship, 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 Lordship. Lordship. In the schedule, Lordship, it is clearly mentioned Vastu. Vastu Pukurpad. There is no means. And in Vastu Lordship, there is no dwelling house Lordship in that portion. Whatever the permit has sold, Lordship. Dwelling house, there is so many dwelling house Lordship, including the present appellant and including myself also. But no part of any dwelling house was sold to that party, Lordship. Yes, Lordship. He is also residing. Yes, Lordship, in that place. And it is Lordship, one side of the pond. Kindly see, Lordship, Pukur part. Lordship. No, Lordship. Demarcated. It is no, Lordship. Lordship 6. Lordship, that for requirements of that person's Lordship. Lordship. Oh, not putting on. Lordship. Lordship, everything there is a different Lordship Khotian number and recorded in the name of the Lordship. 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 But Lordship, Lordship. But my respectful submission, Lordship, that in the these disputes like Lordship, it is Panchayati, Lordship.
My lord, one thing, my lord.
This court, Lordship, not decided that issue, Lordship, because
Yes.
relating to land, Lordship. But in police inaction matter, Lordship. Lordship. Lord. Lordship. 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 Siddhartha Mano, Lordship.
Oblige, my lord.
Date may kindly be given, kindly. Date may kindly be given, Major. Date may kindly be given.
Hmm.
I appear for the petitioner.
From the state, my lord. Regarding, my lord,
The mic.
yes, my lord. Regarding, my lord, the patta land, my lord, the patta which we have given, my lord, that has been, my lord, not accumulated right now because of, my lord, there's, my lord, we have not received any proper instruction till yet, my lord. My lord, because, my lord, the challenges is my lord, the quantum of patta given is land is major, the patta is given lesser, my lord. Patta is given major and land is, my lord, lesser than, my lord, the patta land. I
Explain.
What is the
happened here?
difference?
Under a scheme, Lordship, state government gave land to many landless persons for the purpose of agriculture. Well, that is as per the principle embedded in Section 49 of the Land Reforms Act. And the detailed procedure is laid down under the Land Reforms Manual of 91 as to how this land is going to be measured, identified.
202.
Grateful, my Lordship already knows. So what has happened here, Lordship will see we've got only some examples. In pages 11, 12 and 13, if Lordships see, the total quantum of land is 1.78 acres. But if Lordships add the land which has been given by Patta under that mechanism is 17.65 acres. Well, there obviously has been some significant administrative lapse, and all this happened between 2023 and 2025. So all Lordship that we were looking for, because hundreds of people's faiths are involved, because there are genuine people, there may be people who are not so genuine, who are perhaps not deserving.
Demarcation is not there.
Absolutely not. Otherwise, my lord, the actual plot is 1.75, but the same land has been given. If all that is added, it will come to 17 acres. Therefore, we just wanted, Lordship, an inquiry into this because it concerns a large.
My lord, my lord, they have only prayed for the consider the representation regarding that. My lord, they have filed on representation to the authority, my lord. If that is so, my lord, my lord, the representation is considered, my lord, and upon that, my lord, given a proper reply to them, my lord.
We've also prayed for an inquiry. In fact, that is our prayer B at page 8 of the draft.
When were these pattas given?
Well, all this is between the years 2023 and 2025, as we can understand.
Is it coastal area?
Well, this is Kultoli block in South 24 Pargana.
Nearer to coastal area.
This is, yes. Lordship knows what is happening.
Cancellation
And then, my lord, because my lord, land is
Record of rights does not reveal as to. Apparently, it seems that excess land was given,
Yes, yes,
which
madam.
did not fall within the total amount of land.
My lord, then let it be, my lord, a concrete, my lord, instruction, then come, my lord, kindly give us some time so that, my lord.
And Lordship, there's some subsequent documents which we've got. We've put it in a supplementary. We've served the copy as well in advance. If Lordships kindly take that on record just for the completeness of all the material.
Good morning.
Interested parties.
Instruction বলেছিল।
one hearing we were called for, but my lord, the officer really said because it's on such a large scale, not been able to give us any assurance, and this is after the writ petition was. Well, this is not accusatory. There's something has happened, Lordship. Lordships will only look into it. We really do not want to. It's not really about the blame game.
Page 31 is the hearing notice of the supplementary.
You've given some more record of rights which we obtained and the hearing notice. That's at page 31. So,
ওটা নিয়েও কি করবো? আমরা implementation আর কি যদি যেই existence BLRO to conduct an inspection. Annex the inspection report with the report.
And the Moja map.
Yes, next.
Grateful, man. It's great. Great.
Atmadeep, your key.
This is my public interest litigation, my lord. The petitioner before your lordship is an NGO, my lord, who has been, my lord, a reputed NGO, my lord, who has been working in the field of, my lord, rehabilitation of the displaced persons and, my lord, the all other activities, including, my lord, the giving justice to the persons who have been, my lord, victim of different crimes.
Is that
So
the same organization which preferred the OBC matter?
yes. একই তো আত্মদীপই তো করেছিল
Yes.
yes
Same
yes
organization.
So my lord, what happens here, my lord, before just I, my lord, take your lordship, my lord, to the facts of this case, I must, my lord, candidly say, my lord, on the earlier occasion this matter was taken up. So my lord, this honorable court was
Yes, tell us.
yes. So my lord, the honorable court was, my lord, pleased to, my lord, ask me whether the proposition about whether the third party, my lord, can take part in an investigation, a criminal investigation. So my lord, I start by saying that I am not here, my lord, to take part in the investigation, not at all. But my prayer before your lordship, I'll be just placing your lordship, my lord, facts which would be, my lord, to constitute this honorable court's judgment or orders, and my lord, thereafter.
Is your prayer? Prayer
Yes.
A?
So if I just take your lordship, my lord, to the prayers, your lordship will see prayer A, B, and D. If I just could take your lordship.
No, prayer A, what does it mean? We do not understand.
My lord, I'll just place.
You want a status of a pending criminal proceeding and you want the secure the presence of respondent number 6. Where from?
I tell your lordship this. My lord, here, my lord, the respondent number 6 is the person against whom the criminal case is started. So my lord, the criminal case is relating to a murder. So my lord, the respondent number 6 is accused of the murder, my lord, of my lord, he is said to be the mastermind of a murder of, my lord, Goldsmith.
My husband.
So yes.
What do you?
I'm an intervener, my lord. I have come to know of this public interest litigation. My husband murdered without taken out from the shop room.
May I just
shop room, broad daylight. Thereafter kidnapped. Thereafter he was found dead.
I'll just take your lordship to this. If I just could, my lord, complete my submission to this.
Has been held in the murder, CCTV footage, etc. Everything.
So my lord, here, my lord, what I'm.
You are not agreed by the investigation court. So what did you do?
I tell your lordship.
What did you do? What steps you have taken?
Difficult today, my lord, that this person has in broad daylight committed this act.
We are asking you what is the.
I'll tell. Thereafter, my lord, he was arrested after a rash driving. He was also.
Sir, we are asking since when it is proceeding, what steps you have taken?
May I clarify?
But may I just at least, my lord, place my case?
This case, the charge sheet was filed against 2 persons. He was not in the charge sheeted accused. She did not file any protest application before the concerned court below. We being the authority, my lord, we have formed a seat, special investigation team, to, my lord, reinvestigate the matter. Now the investigation is going on. Warrant of arrest has been issued against this person. But this state has done, and the person is absconding. The due process of law will follow.
Represented by an advocate.
My lord?
Respondent number 6 is represented.
Warrant is pending against him.
You have not surrendered.
My name does not figure in the charge sheet. I have taken out an application, and I am taking appropriate measures, apropos the decision.
Lord, it is my duty to point out, Lord, initially he was granted anticipatory bail by the Sessions Court. After that, that was challenged before this court, before Malaysia's Tirthankar Ghosh. Lord, Tirthankar Ghosh has cancelled the bail. Ultimately, he went to Supreme Court. Supreme Court dismissed his SLP. Immediately, we issued warrant of arrest against him. Now he is counseling himself so that the warrant cannot be issued. Now your lordship knows once the warrant cannot be issued, the other steps are proclamation, attachment. That's a time-consuming process. We are on that. This is the
He's very
situation.
much in the scene. He's happily
But
roaming.
kindly see our report, but he is hiding.
Engaging an advocate.
May I just indicate?
No, no, has warrant been issued against you?
Yes, yes, my lord.
You must have, service was there.
My lord,
Service affected. Warrant executed.
warrant, my lord, court has issued warrant of arrest. So until and unless the person is arrested and produced before the court, it cannot be executed. So he is counseling himself. Although the Supreme Court, kindly see our report.
So when is the next date?
But date I need to.
May I just indicate? Subject to what the learned additional advocate general says. That I had taken out an application questioning the warrant because my name did not figure in the charge sheet.
Initially.
Not initially, the charge sheet is perhaps of January 26. Now, the warrant or issuance of the warrant was questioned by me because since my name did not figure, now the police authorities they opposed my such application before the appropriate criminal court. Now, the criminal court says on the representation made by the state that they might undertake further investigation, wherefore my name might pop up or my name might be included. Apparently there is no FRT.
But sir, we are not on that. He is engaging an advocate. He is suffering a warrant. What is this happening?
That order has been made on the 10th of August. Today we are on 13th.
What order has been made?
Made by the criminal court.
My lord, when Supreme Court has rejected his prayer for my lord, anticipatory High Court's order,
subsequent date,
my lord, Supreme Court said you surrender within 7 days. He did not do so. Kindly see the order
Then
page.
what the High Court has intervened thereafter?
No, 46, page 46. Kindly
No, no, what he is saying. What are you saying?
After the Supreme
Court.
46.
Your Lord, kindly go through this order of 10th of August.
What? Tell us what he has done.
Page 46.
On my application, the ACGM Vidhannagar has rejected my application and fixed a date for compliance. This was questioning my warrant. I had preferred that application because according to
what order did the court pass? The High Court?
Huh? You can't question the warrant because the police might undertake further investigation.
Yes, then 10th August. You have not surrendered.
Legal recourse is being taken by him. And in any event, in a public interest litigation, whether
No, we cannot hear an absconder in a proceeding. You're absconding.
Had I absconded, I wouldn't have appeared to you.
That we do not know. That is your choice. Your client is too confident.
Have rights.
Sorry, sir. He is an absconder. You tell us whether you have Supreme Court directed you to surrender within 7 days.
I'll show you a lot.
Long time back, 19 January 2020.
It was in January. So you are violating the Supreme Court order.
The charge sheet was apparently filed in the proceedings where my name did not figure at all.
So very good. Then you should have gone to Supreme. Anyway, we cannot hear an absconder. Admittedly, it's why your client is not surrendering. What step you have taken after that?
But from 10th August order will come.
So you are violating the Supreme Court order.
With respect, I have my remedies in law. In criminal law, we are subject to correction.
You have remedies in law. You are a party to that proceeding. Supreme Court has directed a mandate in surrender. And you people, what you are doing also, he is engaging an advocate, but he is not surrendering.
He is counseling himself and taking steps. Now kindly see page 46 once. Kindly see page 46.
Height of audience.
Para 2.
Public interest litigation, whether
Para 2.
remedy is available. Inviting the court to go into all this. Kindly also visualize that. It is not at the instance of de facto.
We have not heard him yet. Yes, tell us what is your stand.
All I was just, my lord, trying to impress upon your lordship, my lord, here this cause of action of this public interest litigation is not the murder. My lord, all I was just trying to impress upon your lordship that the conduct, especially when, my lord, there has been, my lord, noticeably, my lord, by this constitutional courts, the observation and
what do you want in this petition? Tell us.
I just want, my lord, by the conduct of this respondent number 6, not being apprehended by the law enforcement agency. My lord, that has, my lord, already convinced the public at large, my lord, that the person who are close to the administration, my lord, can just do whatever they want to do. And my lord, that will be a prejudicial thing, my lord, in the interest of everyone. So I just wanted, since there has been continuous, if I just could take your lordship 2 orders and nothing else, and thereafter, after reading this order, if your lordship thinks that this
What is your prayer in the petition?
that he should be arrested as per the court's direction.
So what
Repeated.
has been issued?
Lordship,
Has been issued?
this is what I was just trying to impress upon your lordship here.
No, what is the maintainability of this petition?
My lord, I tell your lordship, my lord, if I just could, my lord, say that this public interest litigation has, my lord, been filed by this spirited NGO by, my lord, requesting so that the
Why
public,
one particular case you suddenly become interested?
because, my lord, because of the only reason that this particular matter, my lord, has reached to this kind of situation. For that, I'll just taking your lordship 2 orders of this honorable court, nothing else.
First, show your pleadings.
My lord, sees.
What you have pleaded in your petition?
Very well. My lord, kindly seize page number, my lord, paragraph number 15 first, which is at page number 11. Or I'll just relying upon 15, 16 and 17 of my petition. May I please?
এটা কন্টেন্ট ফাইল করে দেবো যা খুশি করো।
You are wanting through this writ petition to pass an order upon the police authorities to immediately arrest him in a public interest litigation.
My lord,
This is your prayer.
my lord, my prayer is to arrest him only for the purpose of instilling confidence on the general public. Kindly seize 37 once. Page number 37 once seize thereafter.
Cases also.
Also kindly seize page number 37. So, my lord, this is an order of this honorable court. My lord, while cancelling his prayer for
By impleading him and by getting the public interest litigation rejected, you will grant further premium to this person.
Exactly.
my lord, I'll just
When you get a rejection order, you will understand.
but kindly once seize, my lord, 37 once why I'm coming before you.
Understand the consequence, Mr. Roy. I don't know what is the purpose. You will be doing more harm in the investigation. If a person comes broad-hearted and says the Supreme Court has denied me bail, very good. I am still have a remedies in law.
My lord,
If I reject this, if we reject this, what would be the consequence?
my lord, why are you?
Think over this issue before.
Follow, my lord,
Like
follow
the post office, please don't come and file a public interest
My lord,
litigation.
follow your lordship. My lord, that
So what
part,
research you have conducted?
my lord, that part is already over. If your lordship kindly seize page number 37 once and 2 orders of this honorable court.
For what? For what? You are wanting us, we
lord,
find prima facie, you
holding-
have no locus to come here. It's a criminal proceeding in between the persons.
My lord, holding that the
Do you
authority
have
is
any
already.
authority? We have understood. Do you have any authority on the issue?
My lord,
Come
I'll
and
just
show
place.
us.
I'll just place your lordship, my lord, 3 paragraphs of one judgment of this honorable court. Before that, if I just could, I have that, my lord. I have that.
Give a copy. Have you given a copy of this report?
This is a reported judgment of 2017 SCC online. একটা copy আছে? আমি আমার copy
You
দিবো।
don't. You keep it with us. You don't give him the report.
My lord,
The confidential one report.
Go through the report and the go through the judgments what you have. You bring. We will decide the matter next Thursday. Yes.
as your lordship please.
And please think over this issue.
As your lordship.
Yes.
Deep please.
Presidential officer appear করে গেল যেখানে right of audience.
Mr. Bujumdar, you also consider your police personnel residential address advocate engaged till you do not find the person.
Lord, he is counseling himself. This is the whole difficulty. My lord, we are trying our level
He is
best.
broadly appearing in daylight through an advocate. and we have
Several
polices.
places raid has been conducted. My lord, we could not, my lord, he was not available there.
So now
We
he has
test out
engaged.
some places, the raid was conducted. My lord, we cannot-
Mr. Mujumdar, you are the additional advocate general. You find that the person against whom you have issued the
I
warrant
understand,
is being represented by an advocate, but you are saying that he is not at home. He is conducting proceedings.
Not
from
only
some-
home, Other places also you have done. so.
Yes, next. Call the next matter. When you come back on next Thursday, please give us this instruction.
Please.
Yes, next.
You are an intervener. Please.
In orally deductible, that would grant a premium to a
You are not granting.
interested litigated person. This is absolutely not.
Yes, who is for
No,
the
I am for the petitioner. This is the evidence service. The municipality is the answering respondent, my lord. Now, kindly see the photograph first. Page 18 and 19. Well, this is the entrance point of yes, sir. The municipality is answering respondent.
Yes, what is your
Now,
content?
kindly see page number 18 and 19. The photographs. Now, this is the entrance point of ward number 1 and 2 of the Joynagar municipality.
I put that.
Now, the municipality forcefully put a pillar over the road, for which the easy access of the people of the locality is affected.
Where do you decide? Where do you decide?
I am the
You are the
social activist.
person residing in that road.
No, the village people of the locality made a representation.
Municipality is here.
Municipality is not here, my lord. My lord, I've tried to get, my lord, we've not yet.
Your service is complete.
Yes, I have served. I have given the evidence service.
Joynagar municipality?
Joynagar municipality.
Allegation is against Joynagar
Municipality.
Mr. Bapin Boydya appears.
No, my lord. The Bapin Boydya is the file the writ petition. The Lokinath Bhattacharya, I think, the appears on.
My lord, we sought, my lord. We are awaiting, my lord. We tried also to get in touch
kindly
for that.
fix next week any date, my lord.
Not yet, my lord.
Kindly fix any next week any day. I inform the Lanyard report of municipality.
Not. My lord, the difficulties, my lord, in these, my lord, pillar erection, this, my lord, everything comes up, my lord, in a public interest litigation, my lord.
Actually, who are aggrieved, they are not coming before us. They are not filing the writ petition.
That is, my lord.
The municipality.
For what reason?
I don't know. Without any reason. There are 3 schools are there. Let the municipality.
1st September, you come back to instruction.
Agreed.
You are not issuing any direction to the debate.
My lord.
It is maintainable.
This is again, my lord.
Just inform us that what is the status.
What is the status and whether, my lord, many a times, my lord, these are, my lord, also whether public roads or not, my lord, these again will have to be checked, my lord. This has to be ascertained, my lord. My lord, also, my lord, locus and all, I did not take this point right now, my lord, when its matter is heard at
on
length.
1st September.
On 1st September, my lord, we'll come back, my lord, with that. I'm so grateful, my lord.
Gratefully.
Matter, my lord. On the last occasion, we have argued, my lord,
Mr. Bhattacharya is item number 12, my lord.
My lord, my lord, Mr. Leonard AG is on his legs. He's arrived.
Leonard?
He's coming, my lord.
Has there been any development as regards?
My lord, only Leonard AG can.
And Mr. Bhattacharya, you repeat it to my brother. He said you come.
It's very short issue. Whether the government, by a general order, direct
instruction, my lord, I am
the
submitting, my
revision
lord.
of all SC/ST certificates starting from 2011. They cannot do because the government is not the authority under the statute. Statute empowers a particular body to cancel on certain exigencies. Here, the decision to revise everything of 2011 is an attempt to create unrest in the society. It's barred by doctrine of dictation. That was the issue. The honorable bench, when hearing the matter, directed the Advocate General said, we will take instruction. Whatever the statute permits, let them proceed, but there cannot be such a blank order.
My lord, under instruction, I am submitting, my lord. Kindly make it not today, my lord.
Abar not today. কতদিন হচ্ছে এগুলো ভাই?
The order. We told him that whether on the basis of this. Mr. You had a talk with the advocate?
Yes, my lord. Just now I was
Then is he ready? Then he has no
No,
problem.
my lord. Upon instruction, junior instructed me, my lord, kindly keep it some on any day, my lord, subject to convenience of my lords.
তাহলে মঙ্গলবার থাকবে। Then let it be on Tuesday. And let it be peremptorily not fixed.
The Tuesday it will be within some first.
Yes.
Yes, my lord.
That day will allow us to pass our.
My lord.
Both the matters are same. No?
Yes, my lord.
11, 12 same matter.
Ask me the advocate.
Yes, my lord.
You have already heard it.
Yes.
Yes or no, let us take.
Deep lovely.
Grateful, my lord.
এবার WPCT নাকি? হ্যাঁ।
Accusation, Lordship. My lord, I'm for the respondent original applicant.
My lord, I'm praying for a short passover.
Independent orders passed are all disposed of by a single order.
Single order. Kindly seize once.
Ordering.
Where is the impute order?
The order date of the order is 2nd of February 2022.
Where from your.
But it should be annexed at the end of the petition. The copy that have been handed over, it is at the end.
এই এটা খোলো।
Number 15, my lord, because in item number 15, all the document is annexed in the item number 15, my lord, of.
Yes, sir.
Yes.
Will there be any problem?
But
You prepared with this.
the all the documents are almost more or less same. So
Same,
if
my
it takes up 15 minutes, I'll just able to assist you.
Now, 15 নম্বর
এখানে লেখা আছে
Your oppositions are on record.
Yes, my lord.
Where you have not filed petitioner.
I'm for the petitioner, my lord.
Opposition, where is your opposition, Mr. Roy?
But I did not use any opposition here because all the
Matter.
because here
You
But-
reply on behalf of the respondent.
but that was
Vivekananda Chaurashia,
yes, Madam.
Das.
Vivekananda Chodashia, item number 15.
See, দাদা এটা করেছো তো তুমি
But that is actually reply, but it should have been malad opposition. It was not rightly.
You have
written
indicated
as- yes,
reply.
yes, I've seen that.
All right. Order impugned.
73 of the read petition, my lord. My lord, as per this RBI 90 of 2009, my lord, there is no provision for any alternative appointment, my lord.
Replaced. Category A1, category A2, B1, B2, there is a classification. There is a memorandum to that effect issued by the Eastern Railway. Where is that?
That is start from page 63.
No. Sure.
So, Mishra, why you are angry?
No provision for the alternative appointment, my lord.
No, kindly come to the internet page 7 of the order.
Yes, my lord, there was a direction for reconsideration. Yes, ma'am.
No, list was given.
Yes, my lord.
It boiled down to the issue that they applied they applied for 5 categories.
Yes, my lord.
Now the problem is as regards his medical, he may be disqualified for one category.
Yes, ma'am.
Does his medical condition deprive him of the other categories
My
also?
lord, that's only I'm submitting, my lord, as per
That is
the.
why it has been sent to you for reconsideration.
Yes, my lord.
But the finding is there, if you argue that now after that list has been prepared, it is evident there, although the applicants had applied against 5 categories in order of preference, many of which required lesser visual acuity than A1 to A3. Respondents are deprived of taking suitable categories as per their next preference and so on. What was the medical? He was initially A1.
A1, ma'am.
Physical, that is
Visual.
something visual.
Visual condition.
Now he was review medical was conducted.
Yes, madam. Re-medical examination, madam.
He was A3 medical category.
Yes, ma'am.
He was sent for D-medical exam. And he was sent treating B1.
B1, my lord.
So there are 5 categories here.
Yes, my lord.
So does his present physical disability entitle him to be considered in the next categories?
My lord, now, my lord, in the year of 2009, my lord, there is a RBI notification, my lord, that no alternative appointment may be given, my lord. Just page 73.
So they are saying board's notification was subsequent to the selection.
My lord, kindly come to page 73, my lord. This is only my main contention, my lord. This is only my main contention, my lord.
Explain to us, he applied for 5. Where is
Yes,
the, where is the employment notification?
Yes, ma'am. अरे खाने में यही extra. (46)
That is the notification.
Yes.
Notification.
Notification.
Yes, 1st October 2000. Now, when did that scheme was abolished?
2009.
My lord, that was prior, my lord. 2009, my lord.
Page 73.
73. That was prior, my lord. This is my main contention.
Regarding provisions of alternative in the same grade.
She's engaged in another court.
page 46, which Shah is showing us. But system of this recruitment, suppose you are A1, to apply for one post.
No. Malad, could your lordship kindly seize Malad page number 50?
50.
Malad, same employment notice. Same employment notice.
Yes.
Malad, at the bottom of the page, 10.2.12. So, Malad, in column number 13, I'll have to indicate the choices. First preference.
13 may indicate his choice by preferring the code as given in para 1.
No, up to 5 preferences.
So I
Para
can.
1 মানে কোনটা?
ওই যে তুমি যেটা আগে
না, তাহলে how can you prefer for a post which does not tally with your medical category?
No, Malad. Before, at the time of employment notice when it is published, Malad, we apply for the post. So in the post, Malad, I can just say it may be Malad, 5 categories of post. That one category, Malad, may commensurate with B1 medical category. One post may commensurate with A1 medical category. So I just give my preferences accordingly. So
if you are not eligible for
no, Malad, at that particular time, eligibility does not arise because this eligibility, Malad, pertains to after my medical examination is done. So it is not, my lord, kind of my present position because at the time when I make the application, nobody knows what is my eligibility.
I see.
So after my application is made, my lord, I qualify in the written examination, then I am medically examined. And then it is seen that my condition commensurate with A1.
Applicant was declared fit in A3 2014.
Yes. What happens here in this particular case, my
That
lord?
is after completion of written test, you emerged to be successful, then it was done.
Yes. Now what happened, my lord? This entire recruitment process, my lord, was stalled by the order of the honorable courts. So after that, my lord, 3 years after, once again, my lord, that interim order was withdrawn. And thereafter, my lord, one
was at the instance of other candidates.
yes,
Other
candidates.
2014, 2016 withdrawn.
Thereafter, my lord, what happens? But now, once again, they decide to do a medical examination again. So at that particular time, when the medical examination was done, I could not qualify for the preference 1, which wanted, my lord, A3 medical category. So I qualified in B1, B2, or whatever it is.
You, after that review medical, you became B1.
Yes. So if what the learned tribunal says that whatever is the present medical category, my case be considered with the other preferences that I have given. If that commensurates with B1,
But
it
the-
does.
But tribunal in the penultimate page says,
Yes.
last line,
Yes,
the
ma'am.
court orders subsequent to notification
Yes.
shall not apply.
But it is with respect
That been brought into play,
it is with respect to something else, not this one.
not this.
No.
Then
It is
this is came in 2009. Alternative scheme.
Yes, my lord.
Alternative appointment was prior to
I
publication.
tell your lordship, alternative appointment this particular notification would not apply even in my case.
Why?
What I was just saying, my lord, this notification which the learned tribunal talks about initially, it is about making a replacement panel. Means when someone if the vacancies are fulfilled, but this is all being talked about there. My lord, the basic contention here, my lord, starts from paragraph number 8, page number 7. Before that, the discussion of the learned tribunal.
Paragraph number 8.
7 of the learned tribunal's order.
7.
My lord, the last but one page number. So that is what, my lord, is my case here. Before that, which is
your which one? Paragraph 8 is the list given.
yes, from paragraph number 7 onwards.
Yes.
Because all the discussion previously, my lord, that has been made, it is with respect to a notification of 2005, which says that a replacement panel is required to be done. And thereafter, my lord, they came up during the process of recruitment with another notification which says no, replacement panel is not required. So we submitted before the learned tribunal that the subsequent notification which takes away the replacement panel system will not arise because this notification is guided.
Take us to those.
That your lordship would see previously in the order.
No, but
now all I was just trying to say, my lord, that discussion may not be relevant here at all, because here only a single point is involved, my lord. That my lord, I chose, my lord, 1, 2, 3, 4, 5. 1 required A3, B required B1, C required B2 like that. And thereafter, my lord, when I was qualified in A3 previous occasion, but however, I could not be engaged because of the court's intervention, and be that as it may. It's not my fault. Let us say it is not their fault as well. Thereafter, my lord, they decide to once again take the medical examination, which I say, my lord, they could not have taken. However, I also submitted myself to the medical examination. Then I could not qualify in A3, but I could qualify in B1. So all, my lord, I was trying to say that I may not get my first preference, but I may get preference number 3 or preference number 4 or 5. This is what the learned tribunal says. And my lord, about the notification that my learned friend, my lord, refers that alternative employment cannot be given. It is not alternative employment. This kind of, my lord, notification is applicable when someone, my lord, why?
Page 73, subject is alternative appointment.
Yes.
Subject of the
But my lord, the notification itself here gives me the right that I can be considered with the second preference, third preference, fourth preference. My lord, the employment notice. Yes.
Yes, my lord.
No, this 2009
My
circular,
lord.
there are cases that we cannot give alternative appointment. Your contention is this is not an
Alternative appointment. This is with the same employment.
How do you say that this is an alternative appointment?
Great.
Because page 76.
My lord, alternative appointment to the medical unfit candidate, my lord.
Now, this concept of medically unfit candidate is not applicable in this case because
My lord, by RRBS and RRCS.
in group C and group D.
Yes, ma'am.
Now, kindly come to the last paragraph of that page. Page 73. Kindly read the matter regarding provision of alternative appointment is same grade. Candidate selected for CT in RRT and fail in the prescribed medical has been engaging the attention of the board for some time. In terms of railway board with reference such and such, presently authorized to consider requests from which candidates for appointment in alternative categories, provided there is an acute shortage. So this is not an absolute bar. They participated for group D post.
Yes, my lord. My lord, in last, my lord, in second page, my lord, 74, para 4, my lord. Para 4, my lord, considering all this except, board have decided to discontinue the policy of providing alternative appointment to the medical fail impanel candidate selected through RRBS and RRCS. For in
Suppose this is operated, we accept your.
yes, ma'am.
Now kindly come to page 50. Page 50 clause 10.10.
10.10. And there was provision to
Yourself, you are giving the choice.
to
That
yes,
5 categories
yes,
you
ma'am.
may apply as per your medical fitness. So one who is A1 can also apply for B1.
Yes, my lord.
Higher.
Yes, my lord.
Is higher. question to you is, you yourself knowing that there is no alternative appointment system, because this is of 2012, who published the notification saying you will get a choice to apply for 5 categories.
Yes, madam. We have.
Then how, Mr. It is by virtue of striking down the alternative appointment, by virtue of striking down the alternative appointment policy, you can prevent them from being considered to the other posts. This is the crux of the matter. So what is
My lord, there is a delay of 3 years, my lord. That's why remedical examination was done, my lord.
He's not, for that he is not responsible.
Page 214, my lord. This is the application which the petitioner respondent has submitted. This is an application which the petitioner has submitted, my lord. Here he had given his preference post, my lord.
214.
Yes, my lord.
15.
14.
215.
15 is different.
What do you want to show, sir?
My lord, serial number 13, order of preference. My lord, the petitioner respondent has given.
Where from you are getting?
Give the name. This is not stated. Is this 22484443? Right hand side top.
For office use.
Last is 443.
443.
Yes, my lord.
Now column.
Serial number 13, my lord.
Serial number.
Serial number 13.
13.
1, 2, 3, my lord. He had given a preference.
Now order of preference.
Yes, my lord. He had given, my lord.
Order of preference.
5,
03, 04, 09, 08, 4.
Yes, my lord.
Yes.
And my lord, here in notification, my lord, 05 is for the C1.
Acha. Coming.
05 is
For C1.
no, he gave 03, he gave first.
Yes, ma'am.
Thereafter 04, 09, 08. Thereafter 14 or only 4.
My lord, first is 05.
This is 05.
Yes, ma'am.
1 minute.
05 is Chowkidar.
Yes, madam, C1. And
he can go for that.
No, I'm not saying, my lord, that he can go for that, my lord. He has given that preference post.
He has given the preference.
First preference.
First preference is Chowkidar.
Chowkidar. That is C1 category, medical category. Is 4.
04 is helper.
B1.
That is B1.
Yes, ma'am.
Yes, C1, B1. Next post is
Is
09.
A3.
That is gateman. That is
A3.
Next is 14.
08, my lord. That is B1.
08. 08 is again B1.
B1. And last is 14, my lord. B1.
Helper.
Yes. So what you are wanting to show?
My lord, at the time of making application, my lord, he has made this preference post, my lord. And we don't have the alternative appointment, my lord, as per the RBI circular.
No, he applied 5 category.
Yes, my lord, different medical category.
Status was 8.
Yes, my lord.
Then due to this delay in
Proceeding, my lord,
became B1.
B1.
So
So
you are testing
already-
person twice.
Yes, ma'am.
When you are testing him after the embargo goes, that now I will test you, now we are going to appointment. Oh, now you are not A3, you are B1. You are not A, you have become B1. Now, when he gets the B1, you are saying that though you have even
Earlier, he was
earlier, that you can go for B1. But I will not allow you to do now, since there was a previous existing policy that there was no alternative.
Yes, ma'am.
Why you are inquiring? You want to show us?
No, ma'am. This much, ma'am.
Please show us from the order how the court has dealt with this alternative appointment.
My lord, that is at page
From the order
page 228, my lord.
228. Internal page?
Internal page 6.
Yes.
Last paragraph, my lord.
Delhi High Court Judge. Fine. Last one that. Yes. Please place.
My lord, that the circular which provide that the policy's alternative appointment has been abolished in 2009 is not applicable, my lord.
Yes. This finding was not.
This finding is
as there is a provision for choosing more than one. And what is this list, Misha? As per order, following list has been placed.
This list of the respondents who were there before your lordship in serial numbers. No.
Oh,
Like
original application number.
Yes, yes.
from item number, my lord, 13 to
Amarjit Shah is item number 13. Amarjit Shah is item number 13. And
so, Miss Shah,
yes, ma'am.
what is the, how do you say your applicant was declared within A3 in 2014?
Yes, my lord.
That is subsequent to the notification, after his application.
Yes, my lord.
A3. Applicant was sent for this. How? Where from did you exercise this power?
My lord, that is at page 161, my lord, as per para 513 of the Indian Railway Medical Manual, my lord. Page 161. 161.
One 161. Ah.
(161). What your
Yes.
513, my lord, para.
Para?
513. Time when candidates are to be sent for medical examination.
513.
No.
Board letter.
No,
Yes.
no. What you are showing?
Page 161.
161.
161.
Yes.
My lord, para 513.
There is no.
Yeah, 500. Oh,
page number
163.
500. Yes. Place. Time when candidates are to be sent for
Medical examination.
Get is selected for a list post for his initial contact them prior to their being deputed for training. In case the candidates were exposed for which no initial training, they should be done at the time of the also.
Yes, ma'am.
At the time of
Appointment, my lord.
But this circular is of 1984. Now, what did the tribunal say about that? So he was sent for re-examination in terms of page 161. Then applicant was denied appointment since he was, his required medical category was 6A3.
A3.
Now cannot apply page para 400 and 530. Medical for conduct as a prerequisite formally. Pursuant to data, an affidavit on behalf was submitted and which discloses applicant indicated history. Having applied for filing in order of preference, now decision to declaring unfit. Candidate ought to have been considered for it. Now, final panel was published, taking into consideration the decision of the medical board. Achha, then he found place in the panel. You were in panel.
Yes, ma'am.
Yes, my lord.
Now you are saying highlight 7.1.
7.1 কোথায় লিখেছিলাম?
Your second medical test was after preparation of panel.
Yes, ma'am.
Eh?
Yes, ma'am.
Yes, ma'am.
Because it is after the interim order was withdrawn. The vacated.
After the interim order withdrawn and prior to the appointment.
Yes.
Just prior to the appointment.
In whose matter? Interim order?
In separate other applicants in this recruitment
What
process.
was the interim order?
That there will not be any recruitment finalized with respect to this RRB notification.
Notification.
Oh,
Or it was subsisted for more than 2 years.
2014 stay,
Yes.
2016 vacated.
Yes.
Thereafter proceeding was initiated.
মানে
এই total.
এই with stay হয়ে রইল তারপর ঠিক আছে tribunal is to direct the regulation so number of cases as were not filled up as well these were failed to apply or one reply দেখা যাচ্ছে আসানসোলের 486 have rejected the claim either no replacement
যদি কোনো ডেট বলে না এখানে ডেট দেখে রেজিগনেশনটা বলো।
life has expired no?
2 years.
No, no, my lord, I tell your lordship, this recruitment appointment process is still, my lord, continuing here of this 112. My lord, that your lordship will find, see the order of the learned tribunal in the internal page number 2 of the impugned order. There was the
RB 73 of 2008.
My lord, which says about the replacement panel, just I said.
That is page 76.
No.
So RB, kindly come to paragraph 6.
Yes.
আরবি কত বললেন?
RB
and applied against the notification of 1 and at that relevant point, RB 73 of 8 was made.
Yes.
Therefore,
that
RB 73.
That your lordship will see in this matter should be around page number 50. I tell your lordship the exact page number. 59.
ভুলে গেছি কোথায় দেখছেন?
My lord, 2005. 37. 2005 is at page number 37 in this matter, and 2008 lordship will see after the recruitment notice.
Where is this RB 73, RB 64, 6 and RB 73?
Yes.
এগুলো কিন্তু নেই আমার কাছে নেই
Not annexed.
Page
not annexed but
not annexed because it's a huge volume.
not annexed
Your lordship sees, my lord, that is the principal guidelines for the recruitment of the Group D staff.
2005
My lord,
RB
yes, RB of 2005, 18th of July 20,
After
2005.
2009, there is another notification.
My lord, it is about the guideline for recruitment.
Recruitment.
Number
The
37.
RB 2011 is there.
No, that is after the publication of the
Find
recruitment
it.
notice.
It is there.
Page number 37, your lordship will see the guidelines of the recruitment. It talks about, my lord,
no your argument paragraph 6
yes,
you have argued this
yes,
that the applicant applied against notification such as at that relevant point RB 73 was operating. What does 73 was variant? Therefore, above mentioned RB, which talks of
केवल आरबी नंबर
replacement
लिख
was
के कुछ टाइम से मांगना है
yes. My lord, that is annexed in a different writ petition. No, possibly not with this.
not annexed
That your lordship will find in Amarjit's petition, page number 59. In a different writ petition that is annexed by them. देखिए, हम part में रखें।
Which those compile you is RB circulars you give a compilation.
You can do that.
That will be
I can
easier
do that.
to dispose of the.
So any
But
other
I-
points you are-
Sorry.
then you finish it up. We are keeping it as forwarders. We pass or deliver our.
Very good.
But prior to that, you have to give us RB.
स्कूटी कुत्ते में
73, 2008.
73 2008, RB 6 of 2014, RB 73 of 2006. These two circular, RB 73 and RB 6.
Yes.
You hand over to our court officer.
By tomorrow. By tomorrow I can.
We have extensively heard
just wanted to add another circular, my lord. I'll just give it to your lordship, my lord, tomorrow. This,
কালকে সার্কুলারটা দেবে
no, my lord,
না না
not true.
Why you want to take?
Because, my lord, they say that alternative appointment cannot be given if I fail in the medical test. But this circular says that it is not a regular failure. If someone has to be medically tested, there has to be a medical board. In my case, nothing has happened.
That further documents you cannot cite.
As your lordship.
My lord, may I?
Grateful, my lord.
My lord, under extraneous circumstances before my lord rises, my lord, my lord, seek liberty, my lord, to move one, my lord, to mention one matter. My lord, at 2 p.m., my lord, an order was passed. My lord Justice Bhattacharya, my lord, sitting in court 5, my lord, refusing me to hold, my lord, a blood donation camp and a health checkup camp on 15th of August. My lord, I have made a prior application before the police authorities, my lord, for such permission. Though, my lord, no such permission till date was given to either of the parties, my lord.
You are mentioning for.
My lord, I am mentioning for a leave, my lord, to move this appeal, my lord, tomorrow. Because, my lord, 15th, my lord,
You have not filed.
my lord, not filed yet, my lord, it's in the process, my lord, my lord.